All right, good morning. I can see numbers are slowly starting to carry on increasing, but early bird and all that. So let's crack on. Well, first and foremost, welcome all to what is the second session in the King's commercial business and property team, specifically the commercial subgroups series of seminars. This is the second of 4 seminars on aspects of procedure. Leslie Anderson, KC, on Tuesday talked about preparing for trials and appeals. And today, I've pulled the short straw and I'm going to be talking about disclosure and witness statements in the next 45 minutes or so. We have next week Jonathan Fletcher-Wright and Harry Dyson talking about abuse of process and Part 36 specifically. By way of housekeeping, this is being recorded and the recording should be made available in due course, as will my slides. So there are some references to cases in the footnotes to the slides. Don't feel that you need to take those references down. The slides will be distributed to everyone who's signed up. By way of introduction, you'll be glad to hear, not going to be talking about all of disclosure and witness statements in the next 45 minutes. It takes up over 60 pages of the white book. It's 2 fundamental and very detailed aspects of the litigation process and simply wouldn't be feasible. What I am going to do today is to talk to you about specifically what happens when there is non-compliance with either aspect, be that disclosure or with witness statements. So dealing with disclosure first, I'm going to talk about paragraph 17 applications under the Practice Direction 57 AD. I will touch upon the overlap with paragraph 18 applications. Well then, and that's where most of the time is going to be spent this morning, about half an hour or so. And then at the end, I'm hoping to spend about 10 or 15 minutes talking through witness statements and what you should be thinking about if you are the recipient of a witness statement that you think is non-compliant with the appropriate practice direction. We've made the promise in the brief that was advertised online that all of these talks will last no longer than 45 minutes. I'm going to aim to stick to that. I should say, if you do have any questions as we go through, please pop those in the Q&A. And should there be any time available at the end, then we can address those. If there's not, I'd invite you to pick those up offline. I have provided my email address on the slide. Dealing first, it comes first in time. It was by way of the litigation process, it was the second practice direction to be formally implemented. We're going to deal with disclosure. As we all know, the disclosure pilot was a living pilot that operated from the 1st of January 2019 through to the 1st of October 2022. It was an iterative process of implementation, so it was being slowly refined over time. I set that out as a health warning because whenever you're dealing with a case that's concerned the disclosure pilot scheme, it's important, of course, to make sure that the wording that you now find under the practice direction mirrors the wording that was implemented at the time of the disclosure pilot. Fortunately for our case, when we're dealing with applications under paragraph 17 of what is now the Practice Direction 57 AD, the wording was the same under the disclosure pilot and Practice Direction 51U, and it was also the same, importantly, for paragraph 18, which deals with, as we'll come on to, applications where what you're seeking isn't an order for compliance with an order of disclosure that's already been made, but you're seeking further disclosure of further documents. And also, importantly, paragraph 6.4 of the Practice Direction, which sets out the factors the court will consider when deciding if something is reasonable and proportionate, which underpins your paragraph 17 applications. I've put as the 4th bullet point on this slide, be on the lookout for transitional cases where the original disclosure order was made at a time where pre the 1st of January 2019, i.e. when the case was subject to Part 31. Now, in the footnotes to this slide, when the slides are distributed, I've provided 2 cases, and in particular, the first case, UTB of Sir Geoffrey Voss's decision. is an important one, confirming that once you're within the scope of what was at the time the disclosure pilot, those are the principles that apply. It's a relatively rare instance for that to crop up now. We're 5 years on since the disclosure pilot was introduced, but it's nevertheless something to be on the lookout for. So that's the brief introduction. Turning now to paragraph 17, specifically of the practice direction. What I've set the provision, there's quite a lot of text here, but I've set the provision out on the slide. What we're looking at here is where there has been you as recipient and the recipient of some instances of disclosure, you think that the other side haven't complied with the terms of the order for extended disclosure. You can make an application to court, should you think it's appropriate, in order to secure said compliance. Now, I've highlighted in purple on this slide some of the key points to have consideration to when you're looking at paragraph 17. So what you're looking for is that there has been or may have been a failure adequately to comply with an order for extended disclosure. And the court may make, if there has been, the court may make such further orders as may be appropriate, and then it sets out a range of options that are available to the court. Paragraph 17.2, this is the test. The party applying for an order under 17.1 must satisfy the court that making an order is reasonable and proportionate, as defined in paragraph 6.4. And then finally, paragraph 17.3 says that an application should normally be supported by a witness statement. So that's the rule. If we step back and think, well, okay, what is actually required under this rule? We're looking here at extended disclosure, not initial disclosure. I'm going to have to assume a working knowledge of the practice direction. But if you're dealing with instances where you think there's a failure by the other side to comply with their initial disclosure obligations, you look at those two paragraphs I've set out on the slide, paragraphs 5.12 and 13 of the practice direction. Ultimately, non-compliance with initial disclosure should be dealt with at the first CCMC. The threshold, the second thing that is worth noting, the threshold that is applied is that there has been or may have been a failure to comply. We saw that highlighted on the slide, the first line. So what that means is the court doesn't need to be satisfied that there definitely has been a failure. It's sufficient for the purposes of the application to satisfy the court that there may have been a failure to comply with the requirements of an order for extended disclosure. And so you can work on inference, because it may well be that the submission that you make to the court is that you think that there has been a failure because there are documents which, for example, are missing. You can't prove beyond doubt because you don't have access to the same documents that the other party, the disclosing party, has based their disclosure searches upon. The third point, and this consideration of adequacy, when we think about it, starts to illustrate why it can be quite difficult to obtain orders under paragraph 17, is because you need to assess whether or not there has been adequate compliance. Now, the assessment of adequacy is something that has been inherited from Part 31. When you look at in Part 31, applications for specific disclosure were dealt with under Rule 31.12. Now, the practice direction to Part 31, Practice Direction 31A, explains in paragraph 5.4 the concept, or it elaborates upon the concept of adequacy. It makes reference to instances where there has been inadequate disclosure. I've provided the footnote and have set out that paragraph later in a later slide to this presentation. But what's clear is that's a concept that has been maintained. So it may well be that case law on the question of adequacy under Part 31 continues to apply under the new practice direction. What you need to think about, though, is that the two are not one and the same. Practice direction, the new practice direction, doesn't have a standard order in the way that under Part 31 there was simply an order for standard disclosure. Here, as is clear from the case law, there's a laser focus here on proportionality and also party cooperation. So it increases, one of the key points is when comparing Part 31 with now the practice direction, is when you think about the methodology. And I say cooperation because the parties are often expected to agree a methodology. After the making of the disclosure order, when you look at the guidance, there's reference to the fact that the parties then go on to agree the methodology, which will be adopted when conducting the disclosure exercise. So you're going to have reference to a methodology in order to determine whether or not the disclosing party has adequately complied. Now, one of the key cases here, which provides some helpful guidance, it's the decision of Irwell Riverside Developments. Again, I've got the case reference in the footnotes of this slide. It's of some local interest because it's a case which fundamentally concerns the Riverside downtown developments in Salford, just off Trinity Way, and some alleged issues with construction. But the reason it's important here is because Neil Moody Casey, then sitting as the Deputy Judge of the High Court, gives some guidance. And at paragraph 14, which I've referenced in the footnotes, he explains that when you're looking to satisfy the court about adequate compliance or a failure to comply adequately, you need to identify with precision where it is that you say that there has been non-compliance. And that ties into the fourth point about assessing compliance. Now, you're going to have reference to the terms of your disclosure order. So there are going to be different disclosure models, possibly for different parties on different issues for different types of documents. So you can see that it's a much more granular exercise. You're also going to need to have reference to the methodology. And I've set out there the paragraph references and also given reference to where in the explanatory notes on completing the DRD, it talks about the fact that the parties can seek to agree methodology thereafter. Also, when you're particularizing your objections as to why you say you want an order, you need to think about the specific disclosure obligations. Those are the ones set out in paragraph 12.1. They're fundamentally the requirement to serve the disclosure certificate, the requirement to serve the extended disclosure list of documents, and then also the production of those documents other than those which are withheld on the grounds of privilege. Those are some of the points. Those first four points are some of the key points to think about. But the fundamental animating principle is that which is set out on the fifth point. It's that the order must be reasonable and proportionate. Going back a slide, paragraph 17.2 set out that test. To apply for and you've got to satisfy the court that the order is reasonable and proportionate, as defined in paragraph 6.4. Now, again, this is a slide with quite a lot of text on. This is the definition of what it lists some of the factors to which the court will have reference in deciding whether an order for extended disclosure is reasonable and proportionate, nature and complexity of the proceedings, etc. I won't read it out. What I will say is that the list here is non-exhaustive, so you can have reference to other factors. And the question one could ask, you could beg the question here, well, these are the factors that the court will have reference to when deciding initially whether or not to make an order for extended disclosure. The court needs to be satisfied that said order is reasonable and proportionate. Where we find ourselves now is in circumstances where there has been non-compliance, or there may have been non-compliance to an adequate standard with that order. So you could say, well, it's got to follow that if the original order, which was deemed to be reasonable and proportionate, now hasn't been complied with, it goes without saying that it would be reasonable and proportionate to enforce compliance with that order. That doesn't quite hold true. And the reason for that is that the assessment of reasonableness and proportionality is to be made at the time of the application, not back in time when the original order for extended disclosure was made. So, and we'll come on to touch on an example taken from the case law, Maher and Maher, which was an instance where there had been found to be non-disclosure, but nevertheless it wasn't deemed to be reasonable and proportionate given the proximity to trial. So we'll come on to explain that. But thinking a bit more about the factors that you consider, these paragraph 6.4 factors, the nature of the non-compliance. So you need to think about, to what extent is this non-compliance? Is it simply a minor technicality that hasn't been complied with? Is it a fundamental aspect of the methodology? Have the dates of search, you say, been wrongfully applied? Have custodians not been conducted their searches such that there has been a non-compliance with the order for extended disclosure? This is where you can see that agreements on methodology, which are expected by the court, if there hasn't been a methodology agreed between the parties, it's going to make it much harder to have that specificity as to the nature of the non-compliance. The impacts of the non-compliance, do you say that these documents which haven't been provided are of fundamental importance to the case, such that you do suffer real prejudice by their non-provision? Or is it a more minor and technical non-compliance, which in reality doesn't have much impact on your preparation for trial? The costs of the non-compliance, of now complying, I should say. So if you're seeking a search that the other side say will be extortionate in its cost and will derive little benefit, then it may be that that's a factor guiding the court. Proximity to the trial date, and importantly, how quickly did you act once you discovered or became aware of the apparent non-compliance? And then these two final points really are quite important, and they shine a light on one of the tensions underpinning these applications, is in that one of the principles guiding the new practice direction, it's set out in paragraph 2.3, is that there is expected to be party cooperation. The court expects to see the parties cooperating with one another in order to resolve matters. If you don't do that and you pull the trigger with a paragraph 17 application without going through in correspondence with the other side and trying to coax the documents out through agreement, the court will take a harsher view. It will be less inclined to allow your application. Also, you need to give thought to whether or not this is in fact the right mechanism to be applied. We'll come to talk about the overlap with paragraph 18, which can cause some confusion. There's not only the paragraph 18 application seeking disclosure of specific documents, which you would say actually fall beyond the original order for extended disclosure, so it's varying the order for extended disclosure. But under paragraph 11 of the practice direction, you'll be aware that parties can seek guidance on the disclosure, the disclosure exercise. And you can also, under paragraph 6.9, be asking the court to resolve or determine issues regarding disclosure. So if the genesis of your dispute here is in fact an argument about what's the correct approach to take given the methodology that you've adopted, the manner of the data search, the analytics to be provided, the nature of the custodians who should be included, it may not in fact be an order. This complaint that we're dealing with here comes later down the line. It comes when the terms of the order are clear, they've been implemented, and then you say they've not been complied with. But if your complaint lies earlier in the process, it's about what should this order be requiring, then you need to be thinking about whether there's a different application to be making. So I've mentioned the case of Maher and Maher. It's a 2019 decision. It's actually involved Mark Harper, KC, who will be speaking later in this series he'll be talking on injunctions, it was an application brought within a familial dispute regarding a family trust. And the claimant brother was seeking to have his two of his brothers, the two defendants, removed as trustees of the trust and seeking a sale of one of the largest and most valuable assets of the trust, a company group. The claimant brother issued an application in June 2019 for disclosure of his brother's personal bank accounts because it was his belief that they were using company funds in order to pay for the legal proceedings. Now, the hearing took place on the 26th of November 2019, so approximately 5 and a bit months after the application was made. But the trial was listed for 7 weeks, time from the date of the hearing. It was listed for the beginning of January 2020. Now, His Honour Judge Hodge, sitting as a judge of the High Court, found that there may have been a failure by the defendants to adequately comply with the disclosure order. There was an argument that these bank statements should have been provided. Nevertheless, at paragraph 18 of the judgment, he took the view that it would be disproportionate. It was not reasonable and proportionate to require disclosure of these documents that maybe should have been provided, given a number of factors. Importantly, it increased the volume of work that would have to be done immediately prior to trial with the Christmas and New Year break. The documents may or may not have supported the pleaded complaint, but fundamentally, the complaint was one regarding administration of a trust. The underlying allegation about payments of bank using company funds was more relevant to an application to a claim concerning breach of fiduciary duty, which was not the motivating force of this claim. The court didn't want to set further hairs running close to the trial date, and so it dismissed the application. So that gives you a good example there of the fact that the concept of reasonableness and proportionality actually can be a very important one in defeating applications, particularly when brought close to the trial date. So it's always a factor to have consideration to when making your Part 17 application. Make sure you've given thought as to why you say the factors set out on the slide should lead the court to make an order. The relationship between paragraph 17 and paragraph 18. At the end of this slide, I talked about the fact that there were different avenues that you may have to consider. Now, the main avenue to consider when thinking about a Part 17 application is Part 18, which I've set out on the slide here, and apologies for jumping around a bit, but I just want you to see the title. As you can see, it says varying in order for extended disclosure, making an additional order for disclosure of specific documents. Now, previously, Rule 31.12 under Part 31 captured 2 instances, both where there had been allowed for 2 applications to be made. Firstly, an application for disclosure of specific documents, and secondly, and this is where that reference to the Practice Direction 31A can be found in the footnotes, if your complaint was that there had been a failure to comply with the disclosure order, what would have been an order for standard disclosure, you would go under the guise of a Rule 31.12 application. Under the new regime, those 2 complaints are dealt with separately. If your complaint is that there's been failure to comply with a pre-existing order for extended disclosure, you're making a paragraph 17 application. If your complaint is that you're looking for an order, or what you're looking for is in fact making an additional order for disclosure of specific documents, or you're looking to vary the pre-existing order that has been made, then you go off after a paragraph 18 application. So paragraph 18 is set out on the slide. Paragraph 18.1, court may at any stage make an order varying in order for extended disclosure, includes making an additional order for disclosure of specific documents or narrow classes of documents relating to a particular issue for disclosure. the party applying for an order, this is where we see the test for a paragraph 18 application, and I've highlighted the key aspect. But the party applying for an order under paragraph 18.1 must satisfy the court that varying the order for extended disclosure is, and it's two-limbed, necessary for the just disposal of the proceedings and reasonable and proportionate. We've seen reasonable and proportionate under paragraph 17, but you can see that there's an additional aspect here, that it must be necessary for the just disposal of the proceedings. 18.3, the application must be supported by witness statements, and again highlighted, explaining the circumstances in which the original order for extended disclosure was made and why it is considered that order should be varied. And then paragraph 18.4 sets out some of the court's powers. So the key points to highlight, I've explained that now, under the new regime, there are two routes depending on the nature of the complaint. And importantly, there are two different tests. Under paragraph 17, the order must be reasonable and proportionate. And under paragraph 18, not only must it be reasonable and proportionate, it must be necessary for the just disposal of proceedings. It's been recognised in the case law, and I've got a reference to a relevant case, Agents Mutual, in the footnotes, but it's been recognised in the case law that the test under paragraph 18 is a higher one. It needs to be necessary for the just disposal of the proceedings. What hasn't necessarily been elaborated upon, in my view, in the case law, is that, yes, the test is higher. And so it talks about the fact that paragraph 17 is a lower test when you're saying that there's been non-compliance with an existing order. But that doesn't necessarily make it an easier application to clear the hurdles of, because in order to satisfy a paragraph 17 application, you need to establish that there has been, or there may have been, a failure to comply with the original order for extended disclosure. And even by mentioning some of those points that are relevant, previously we were talking about the methodology, the need for data custodians to be considered, the need for the date ranges to be identified, and then to apply specificity as to why those haven't been complied with. You can see that there is still an extra hurdle to clear in the paragraph 17 case, which isn't necessary in the paragraph 18 case. You don't need to satisfy the court that there has been a failure to comply with a pre-existing order when making a paragraph 18 application. But ultimately, where does this lead us to? Is that you need to think about whether, in fact, it's necessary to make a dual application on alternative basis. So firstly, make a paragraph 17 application on the basis that the court is satisfied that there has been or may have been a failure adequately to comply. But in the alternative, if there hasn't been, if the court isn't satisfied that there has been such a failure, we nevertheless make an application and under paragraph 18 on the basis that the documents that you're seeking, not only is it reasonable and proportionate to make the order that you're suggesting, but it's necessary for the just disposal of the case. And I've put witness evidence addressing both tests. See paragraph 18.3. Coming back to paragraph 18.3, just to remind you, when you're making a paragraph 18 application, your application must be supported by a witness statement. And this is where we see what's required. Explaining the circumstances in which the original order for extended disclosure was made and why it is considered that order should be varied. So you can see there quite a lot of information is going to be required. You will be providing the DRD to the court as part of your application, and there'll be a list of issues. There'll be models for particular issues broken down possibly by party and by type of document. But you need to explain why those models were chosen at the time, why those dates were chosen within the methodology, why those custodians were chosen. May need to have reference to correspondence at the time, firstly. And secondly, you then need to go on to consider, to explain to the court why it is you say that the order should be varied. I've set out in the footnote to this slide, which explain the relationship with paragraph 18, a case, Agents Mutual, where Mr. Justice Marcus Smith was considering an application for disclosure. Now, the language in the application talked about deficiencies, and there's some quite helpful commentary, and I've put some paragraph references to particularly helpful sections in the footnotes, where Mr. Justice Smith is talking about whether or not it is to be treated as being akin to a paragraph 17 application or a paragraph 18 application. And he said that ultimately, if he'd had to decide, he would have treated it as a paragraph 18 application. But the takeaway message here is that clearly, unlike the previous position, where you'd simply have reference to Rule 31.12, under the new regime, you need to give it the matter further thought, and if necessary, be considering making alternative applications. So we can deal with this quite quickly. How do you make your application? If you do deem that one is required, you've gone through those processes, or you've considered the points I've highlighted about the need for party cooperation. You've considered the points in correspondence with the side. You have decided that this isn't an instance where actually what's needed is disclosure guidance. You make it by way of Part 23. The application should normally be supported by a witness statement. I think there are very few instances where the application notice is going to be sufficient space to set out the grounds upon which you say it's reasonable and proportionate. So I would treat that as quite often you're going to want to have the witness statement, you're going to want to be appending correspondence. And as for timing, this is an important point, and it's relevant back to that Maher decision. But act quickly once it becomes apparent that you have reached an impasse with the other side. You obviously need to go some way down that route to show that this is reasonable and proportionate. But one of the key issues in the Maher decision for His Honour Judge Hodge was that there had been a delay between the date it was at the end of January that the disclosing party refused to provide, and then the making of the application, I think it was about 5 months later, for which there was no good justification. So we are coming to the end now of the section on disclosure. There was a lecture, the Conbar lecture in January of last year. The Chancellor of the High Court, Sir Julian Flo, said at paragraph 56 of the lecture, and I've got the link to the talk, that it is remarkable how few specific disclosure applications there have been under the new regime. And he justifies this, as I've got on the slide, that problem areas are being dealt with upfront through proper engagement rather than being stored up for later. And that could well be correct. It's clear now with the need for more specificity around methodology and agreeing the approach to be taken towards disclosure, that there's less scope for disagreements as to what standard disclosure amounts to, as was the case under Part 31. Moreover, another factor to consider is that under Part 31, the practice direction, which I've mentioned a couple of times now, explains at paragraph 5.4 that there was a presumption previously that where there had been a failure to comply adequately, the court will usually make such order as is necessary to secure compliance. So there was a presumption there to aid the applicants if they could establish non-compliance. The case law is demonstrating that need for reasonableness and proportionality is being taken very seriously. This does mark a culture change in the approach the courts take towards disclosure. So there is more specificity and that may be dissuading applicants. There are, as I've said, other explanations available. It may be that we are simply here in relatively uncharted territory. The disclosure pilot has been with us for a while now, but it has taken time for practitioners to get to grips with its provisions. So that may be one possible explanation. Another explanation may be that the practice direction is having its intended benefits. It's securing the need for party compliance and for cooperation and engagement. So it's actually quite hard to get to this stage. A less positive explanation and justification may be that it's actually the nature of the application itself has become more engaging, more demanding. It's going to require time and detail. You need to take the courts through potentially quite a wide range of documents. You need to be considering pre-CMC discussions and correspondence, which led to the making of the DRD, or the agreement or approval by the court of the DRD, subsequent discussions about methodology and about the assessment. You need to particularize the methodology and what's actually been done. So you need to demonstrate non-compliance. All of that means that an application becomes more expensive and with it, potentially more risky. And as we see from the Maher decision, it may take time to prepare. And if you're being provided with large volumes of disclosure, working through those documents takes time. By the time that you've identified the issues, you've raised them in correspondence, you've tried to work through them, it's not been successful and you're making an application, you may find yourself not at the door of court, but a few weeks out from court, where the court is going to, unfortunately, take a dim view on an application being made. So those are some thoughts on disclosure. We've taken just over half an hour, about 35 minutes. So we'll turn now to consider witness statements. So the next step in the litigation framework, the implementation of Practice Direction 57AC actually came before AD. It was the third practice direction introduced under 57A, came into force on the 6th of April 2021. So it's been with us for over 4 years now. I'm not going to go through the background in too much detail. We know why it was introduced. We know the motivating concerns about statements being overly lawyered, issues regarding the fallibility of memory. The practice direction is structured in two parts, as we know. It's got 5 paragraphs of the primary practice direction, and then its statements of best practice follows thereafter. It's worth noting that it is a slightly odd framework to adopt, to the extent that both the practice direction and what I've termed the SBP will contain rules that need to be complied with. The certificate of compliance, which appends a witness, or which is provided alongside the witness statement, makes reference to both. And in fact, there's one of the key cases here, Mansion Place, notes that you should really be using the statements of best practice as your checklist to make sure that you are avoiding breaches of the practice direction. 3 fundamental new substantive requirements. The requirements to list the documents to which the witness has been referred to under paragraph 3.2, the confirmation of compliance by the witness statement, by the witness, and then finally the certificate of compliance being provided by the legal representative. So what we're dealing with here, before I go on to the slide, we've talked previously in the disclosure arena about what to do if, as recipients of documents, you think there's been non-compliance with 57AD, the steps to take. If you now receive a witness statement that you don't think complies with either the rules under the practice direction or the statements of best practice, what should you do? Well, paragraph 5.2 of the practice direction explains the sanctions that are available to the court. The court may do one or more of the following, and it sets out a menu of options: the refusal to give permission to rely on or strike out part of a witness statement, order that it be redrafted in accordance with the practice direction, making adverse costs orders, or ordering a witness to give some evidence, some or all of their evidence in oral examination in chief, which is a concept that we haven't seen in the civil courts for some time. What's not there on the slide, and a sanction that should be fundamental when you're thinking about the approach to take. What's my strategy to receiving a statement that's non-compliant? One of the key sanctions available to the court, if you keep your powder dry and hold back any complaints until the date of trial, is that the court may regard the non-compliance as impacting their view on witness credibility. So when you're dealing with those he said, she said disputes, and you want to undermine the other side witness credibility, this can be a key aspect or a key weapon in your armoury. What I should say is that this fourth sanction, order a witness to give some or all of their evidence in chief orally. In my reading state, I've read a number of the cases in this area. I'm not aware of any of the reported case in which the court has proceeded to make the order for evidence to be given in chief orally. There's the decision of Greencastle, which is a decision of Mr. Justice Fancourt. He actually declined that option. It was in a case that he said involved the greatest degree of non-compliance he'd seen in his time under the practice direction at the time. The decision was in 2022. But he declined to order evidence be given orally because he said it would create an imbalance it would create unfairness between the parties to require that. So I'm not aware of it actually having been ordered. Now here, I've set out in the next 3 slides some cases, and I say some cases because this isn't all of this list is by no means exhaustive of cases concerning the practice direction. The first 3 cases on this first slide are particularly key cases. The Mansion Place and the Blue Manchester case came very early on in the implementation of the practice direction. And Greencastle, the one I've just mentioned, decision of Mr. Justice Fancourt, gives some insight into the approach that the courts will take. We will dive into those on the next 2 slides. So this slide and the following slide, I've provided you with more recent cases running up to 2023, which I think are of some particular interest for the reasons, for the decisions that were made there, or for some of the principles that are set out therein. What's clear is that this does attract more case law than paragraph 17 under the disclosure regime. Some of these judgments concern discrete applications that were made by applicants, so recipients of non-compliant witness statements. Some of these judgments are in fact trial judgments where the trial judge has dealt with the issue of non-compliance at trial. We've got just under 5 minutes left to keep to our timings. So on this slide, I've set out what I see to be 4 key takeaways to take from the case law. The first is that there is clearly a reluctance from the courts to strike out witness statements, except in the most serious of cases. And when they do strike those witness statements out, they will nearly always allow the witness, the non-complying party, to have another go. It might be on strict timelines. It may be with penal consequences. But there is a strong reluctance to simply disallow a party to have permission to rely upon its witness evidence. The second point, and we'll quickly go through some case laws examples to substantiate these principles. But the second point is that the responding party is expected to engage early when receiving a witness statement. So if you think that there are issues with the witness statement, holding that point back to make an application close to trial is not going to be looked kindly upon by the court, which ties into the third point, which is that the earlier the application, there can be the better the prospects if what you're seeking is strike out of a witness statement and order that it be redrafted in a compliant manner. And then fourthly, and this really is, despite being hidden at the bottom of the slide, this really is a key point, which is that the court does not want to allow 57 AC to be used as a weapon with which to batter opponents and to lead to disproportionate satellite litigation. So the first point, strikeout being exceptional, I've explained the Greencastle case. There, Mr. Justice Fancourt agreed with complaints about the witness statements. They were looking to strike out identified passages of one, completely strike out the second witness statement in its entirety. The judge actually said at paragraph 9 he was unsure as to whether the witness or the lawyer who signed the certificate of compliance had ever read the practice direction, because the first witness statement of the witness did exactly what the practice direction was trying to prevent. Nevertheless, despite saying in paragraph 24 that this was the clearest example of non-compliance he'd seen, he didn't refuse the party permission to rely upon a witness statement at all. He instead ordered the claimant in this case to prepare a replacement and fully compliant statement. He wasn't, in this instance, given the degree and the nature of the non-compliance complained about, willing to leave that matter until trial. The second decision on the slide, the Kieran Corrigan case, it's a decision of Mr. Jonathan Hilliard. It's interesting here. It's a trial decision, not an application decision. The defendant had made an application for relief from sanctions to seeking permission to rely upon what it recognised to be compliance statements, that it had filed non-compliance statements. The judge ordered the defendant to pay the claimant's costs of that application. The judge recognised at paragraph 377 that the nature of the non-compliance could have caused prejudice to the claimant because the evidence may be unreliable. But nevertheless, despite those recognitions, he was nevertheless willing to allow the defendant permission to rely upon statements which were then argued to be compliant. Just taking these final points at a bit of a canter, respond and engage early. I've got a helpful quote here from Mrs. Justice O'Farrell in the Mansion Place decision, one of what I would say the key early decisions in setting out some of the principles that guide the court. Here, this is where the court is focusing in on the need for the responding party to engage early and not leave the matter till the last minute. I won't read that out given the time, but tied into that, the need to apply early. We've got the Vainker decision here. Mrs. Justice Jefford refused an application to strike out passages of witness statements or redrafting in a compliant manner. There had been a 3-month gap between the witness statements being served in March 22 and the application being made in June 22. The application was made 2 weeks prior to a PTR. Couldn't be accommodated at the PTR. It was listed separately. There were 129 pages of witness statements, and virtually every page, according to Mrs. Justice Jefford, had complaints about them. She recognised that some of those complaints were valid and helpful. Nevertheless, what she said was that she could have only given judgment on an application of this size by reserving the matter and working through it on the papers. And given the proximity to trial, the application was being heard on the 28th of July, trial on the 4th of October. She wasn't willing to deal with it because she did not think that would be of any benefit to the parties. What she did instead was said that it would be a matter that could be dealt with by the trial judge at trial. Stepping back, there are no hard and fast rules, because in the Greencastle decision, Mr. Justice Fancourt took the other approach. Finally, and I've said this is really a fundamental principle, avoiding disproportionate litigation. The very first paragraph of the White Book, the commentary before you get to the practice direction itself, sets out on the slide, which is set out on the slide, explains that the making of oppressive or disproportionate applications can lead a party to be at risk of adverse costs being awarded on an indemnity basis. Curtis and Zurich is a fantastic example of that. His Honour Judge Keyser, sitting as a judge of the High Court, it was a claim concerning allegations of fraudulent misrepresentation regarding things that had been said, inducing about 150 claimants to buy flats, and it was issued with the cover notes issued by Zurich, looking for strikeout of 4 witness statements in full, partial redactions of 29 witness statements. The application was successful, and that the judgment concerns costs. Now, despite the first defendant making a successful application, the judge nevertheless ordered the successful winning party to pay the claimant's costs on an indemnity basis, assessed at 75% of the claimant's costs assessed on an indemnity basis. The cost of the application were over £275,000 plus VAT. And what the judge said was the fact that the first defendant's application contained some good points did not justify making the application. And I'm going to finish with a quote. I won't read it out, but for me, this is from a recent decision of Lifestyle Equities. It captures and synthesizes quite nicely a number of the factors that the court will take into consideration. I can see the time. We have run over by about just under 5 minutes. So I do apologise for that. Apologies, that's gone at a bit of a canter, but hopefully you will have taken some, there should be some key learnings in there, both with regards to the disclosure exercise and the witness statement exercise. I can see there are a couple of questions in the Q&A. Given the time, I'd suggest that if you would like to pick those up with me offline, my email is on the slide and we will end it there.